He's going to have to start being honest. That's not a Robitussin blow at all.
That's what I want.
Court calls the case, People versus Xavion Priester.
Ashley Lonnie for the people.
Afternoon, Your Honor. May it please the Honorable Court, Jerome Barney P. 28321, representing Mr. Priester, who's standing to my right.
State your name.
Xavion Priester.
All right. Well dressed. All right.
And I asked the prosecutor if they had any particular offers. They said to wait for the prosecutor who's in charge of this case to talk to them.
Your Honor, unfortunately, the defendant is still testing positive for THC, and he's been on bond now for about 2 months. I'm not willing to negotiate any offers in this case, so I'm concerned that he's still potentially using. I know the court said that if he continues to test positive, it's going to request levels. I haven't received anything with levels yet, but I don't know if the court has, since asking.
It was last year on October 3rd. And I know your attorney told you that you shouldn't be using. So, young man, I'm just going to ask you one question. Yes. Have you stopped? Because okay, and so that you understand, I'm going to call over and get levels. And so I'm going to know. And I know because I was giving your attorney an opportunity. He was going to talk to you about it, and I'm sure he did, because he's a man of his word. So my question to you is, have you stopped?
No, I haven't.
Why?
Made a mistake and it won't happen again.
Couple wallet. Why?
Stressed out.
I'm sorry, I couldn't.
Said he's stressed out. So you lied to the court when you did that. You lied to your attorney.
He didn't lie to me, Your Honor.
He told you he was going to stop the last time he was here.
He did say that. When I asked him if he stopped, he told me no. And because he was stressed out.
What are we going to do on this case? You want it set for exam? You want an adjournment, counsel? What do you want me to do?
Your Honor, we've, I think I've gotten through to him about.
I don't know whether you have, counsel. Mr. Roney, and I'll tell you, I have the utmost respect for you. I know you sat there and told this young man the right thing to do. I know you did. He's just not listening.
Your Honor, his issue is he's got a serious case that we're trying to negotiate some sort of something that will give him a chance to be a productive person.
I know, counsel. And I'll tell you what I'll do. At this point, I'm going to set a probable cause conference for next week, 31st, 2024, 9 a.m. or as your Zoom invite indicates at this point, because you violated your bond conditions. I gave you a break, told you not to do it. You gotta understand, you gotta quit playing around.
I will. Made a mistake.
No, you didn't make a mistake. Here's what you did. You decided you wanted to do it your way. And everybody was trying to give you an opportunity not to do that. And you messed it up. That's what's really happened.
Yeah.
And as much as it pains me, now you've got to face the consequences for it.
All right.
So I'm setting it for next week, counsel. At this point, I'm going to revoke his bond, defendant's remanded. And then we can figure out how we can go forth.
That concludes this matter, Your Honor.
Yes, sir.
Thank you.
Thank you. Court does call the case of People versus John Johnson.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Johnson. Mr. Johnson, can you state your name for the record, please?
John Johnson.
Your Honor, today is the date and time scheduled for sentencing. I did speak with Mr. Johnson. I did review probation's recommendation. We do ask that you adopt probation's recommendation. He additionally did complete his assessment yesterday. It was delayed, but he did complete it, and I did get a report from Von Schwartz.
Teresa Claire on behalf of probation. Your Honor, I can confirm that Mr. Johnson did complete the assessment with Von Schwartz yesterday. I got a copy of that emailed to me last night. I do have some concerns about Mr. Johnson's honesty when he was answering the questions at Von Schwartz, given the report that I breezed through. I haven't had a chance to look at thoroughly to give a recommendation. At this point, Your Honor, I guess I would ask that Mr. Johnson be remanded and that we adjourn sentencing to February 28th. That would give me a chance to take a look at that, and it would also address his bond violations. There's been continued use of drinking while on the sober link. The court did get that report and the bench warrant was issued, so the case is currently on bench warrant status as it is.
Anything you want to say to that particular recommendation?
Your Honor, Mr. Johnson and I did have multiple conversations about the report. Frankly, he admits in part to drinking and denies in part in drinking.
Denies which part of drinking?
He denies the, Your Honor, if I may get my computer back to the exact page. He admits that he drank on the first
The November, December dates?
the February 1st date.
So he admits to those.
He admits to that date.
That's it?
He says the other date he did not consume alcohol.
Well, hold on. Because on February 1st, he's admitting to those.
Right.
There's then blows on February 2nd. He's not admitting to those.
The 7th.
The report that I sent you. He's not admitting to the 2nd or the 7th. He says that he did not consume alcohol. The only time he says he consumed alcohol was on the 1st. And again, it's the explanation in the report. I was hoping that.
Well, the explanation in the report is relevant to the court.
Right. That's why he says he consumed alcohol that day. He says he did not consume.
So hold on, just so that I'm clear on this. He's here on operating with blood alcohol, with a high blood alcohol content. I give him the opportunity, he's released on a sober link, violates the sober link, right?
Yes.
Gets mad and then drinks.
He says that he was mad because he did not drink alcohol that day. He drank Robitussin, but then did have
Which date he drank Robitussin?
says on the 26th, I'm sorry, on the 25th, there's a positive blow, the first one being a .028. Told the agent that he drank cough syrup. And then on the 1st, he also had a positive blow. And he did admit that he consumed alcohol that day.
He's gonna have to start being honest. That's not a Robitussin blow at all.
That's why I'm sorry, I don't mean to interrupt. I'm here to, I'll take full responsibility for my actions, Your Honor.
Well, you gotta start being honest.
I'm very.
Because your attorney's up here telling me that it was a Robitussin blow. You get mad because I issue a bench warrant because there's alcohol showing up in your system, which, oh, by the way, you're not supposed to have anything with alcohol in any respect, whether it be Robitussin, whether it be beer. It doesn't really matter.
Yeah, absolutely.
But I'm looking at the numbers. There's no way you consume that much Robitussin and then blew into that machine. It didn't happen.
No, that's why I'm here.
Then I issue the bench warrant. You get mad and decide to have a beer.
I did, Your Honor, and I take full responsibility for my actions. I'd like to apologize for the time.
Then I've got blows on the 2nd, which you're not admitting to. I got blows February 7th, 2024. You're not admitting to that. I got blows on the 8th, which, well, on the 8th, you didn't retest. Then on the 9th, I've got blows, which you're standing here before the court not admitting.
I'll admit to all of them, Your Honor. I'm not sitting here trying to blow smoke up the court. I'm here to take responsibility.
So you can do whatever you want to do, but I'm just trying to figure out what you're admitting to.
I'll take.
Because look, young man, listen. You want to play a game with me, I'm probably not the judge you want to do that with. So you should probably talk to your attorney. Do you have the full report, Ms. Farney?
I just got from Ms. Pilar the 9th and the 10th where he did not retest.
The 9th and the 10th.
I'm sorry, the 9th, there was a positive test as well. And then it goes from the 9th into
The 10th where he just didn't retest. And then on the 7th, you see that one, February 7th?
Right, yes, I have that report, yep.
And on the 2nd, there's additional flows on the 2nd of February where alcohol comes back.
Right.
Then on the 7th, where alcohol is picked up, and then on the 9th. So apparently he was mad about the bench warrant for a long time.
I'll plead guilty to all of them, Your Honor. I'm not trying to play games with you.
I didn't hear you.
So I will plead guilty to all of them, Your Honor. I'm not trying to.
Did you do it?
Yes, sir.
Then why'd you tell your attorney you're only admitting to one? You knew you had been drinking. You also know it wasn't Robitussin. You know something? You're just going to have to be honest.
Yes,
At some point.
yes, Your Honor.
What's your next sentence in there?
Next is the 28th.
That's in a 1.
Yes.
Adjourn defendant sentencing in this matter February 28, 2024 at 1 p.m. Defendant is remanded to the Washington County Jail. He's to be held without bond pending sentencing. Defendant remanded.
In both of these cases, the outcome comes down to one thing: accountability. The first defendant lost his bond because he ignored clear conditions and kept making the same choices. The second defendant lost credibility by trying to downplay violations that were clearly documented. And in both situations, the judge responded the same way, by removing freedom and resetting control of the case. This is the reality of the courtroom. You can make mistakes, but how you respond to them determines everything. Honesty, responsibility, and consistency matter more than excuses. Now, I want to hear from you. Do you think the judge was too strict? Or were these consequences completely justified? If you found this case as shocking as we did, Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.